The fact that, you could be dealing with an oil and gas dispute one day and dealing with, a defense contract, a defense-related dispute the next day, that is, that keeps you on your toes. It makes, your practice a lot more interesting. And to some extent do advocacy, but you have barristers for that. Whereas in our practice in India, it's, as advocates, you can do both.
A young lawyer should need to develop today, especially in arbitration and litigation. Hello everyone, welcome to yet another episode of DNLU Podcast. Today we are delighted to have with us Ms. Anjali Anchayil ma'am, a distinguished legal expert specializing in commercial arbitrations, litigation and complex corporate insolvencies. Ma'am is a partner at JSA. She has extreme experience handling cases before India's top courts and tribunals. She has significantly contributed to key legal reforms, including 2019 amendments to Arbitration and Conciliation Act and drafting the Insolvency and Bankruptcy Code. Welcome, ma'am.
Thank you.
All right. So, ma'am, my first question to you would be, you have had a remarkable career spanning both domestic and international legal landscapes. From working with Clifford Chance in London to your role as a partner at JSA, could you share with us what initially drew you to specialize in dispute resolution?
Right. So when I started out, I did a training contract with Clifford Chance. In a training contract, you actually get exposure to 4 different practice areas. So my first 2 seats were in banking. I did that out of London and Hong Kong. My third seat was actually in the litigation and dispute resolution team at Clifford Chance London. And what really struck me was the sheer breadth of matters. So when it comes to dispute resolution, no 2 matters are actually alike, right? Whereas, in a transactional practice, especially in a sophisticated market, there's a lot of uniformity, the sort of input that you can bring in as a lawyer, especially in your early years, I felt was lesser compared to what you can do in a disputes practice. And yeah, I mean, the fact that, you could be dealing with an oil and gas dispute one day and dealing with, a defense contract, a defense-related dispute the next day, that is, that keeps you on your toes. It makes, your practice a lot more interesting. And that really is what, drew me to dispute resolution. I also enjoyed the advocacy aspect of it. And that's something that, especially in India, as advocates, we have the opportunity to do. I don't know if you know, in the UK, it's a dual sort of practice where you have solicitors who, do a lot of the drafting of the pleadings, the strategy, and to some extent do advocacy, but you have barristers for that. Whereas in our practice in India, it's, as advocates, you can do both. And that was also one of the things that I liked.
Okay, thank you, ma'am. My next question to you would be, you have assisted in drafting 2019 amendments to the Arbitration and Conciliation Act based on Sri Krishna Committee's recommendations. Can you share some insights on these amendments on Arbitration Act?
I think the Sri Krishna Committee report was probably one of the first reports to comprehensively look at, institutional arbitration. How have our institutions fared? What have other jurisdictions done to improve the culture of institutional arbitration? The amendments to the act that were suggested were also sort of, meant to iron out some of the niggles that were in our arbitration legislation, and also the some of the niggles that were left following the 2015 amendment. I think one of the biggest changes is really to do with the appointment of arbitrators. There's also a voluntary proposal to have something called as the Arbitration Council of India, which would sort of recognize great arbitral institutions. All of this was sort of geared towards, improving the quality of arbitral institutions in India. And that, I think, is something that, we've just have a draft of another amendment bill out. And all of those changes are actually coming from that.
Ma'am, looking ahead, what are some emerging trends in arbitration that young lawyers should keep an eye to remain competitive in the industry?
I think when it comes to an arbitration practice, attending conferences so that you sort of keep yourself abreast of, developments. You also have good blogs where, as soon as a judgment comes out, there is, good analytical writing on it. There are also more opportunities for younger arbitration practitioners and students to pick up some of the things that you would use in an arbitration, right? Learning your advocacy techniques, how to do a cross-examination. All of these are very, very important and practical skills that you need to know. And those are areas in which I think you can, as a younger practitioner, focus.
Okay. All right, ma'am. My final question to you would be, you have taught at National Law University, Delhi, and have actively participated in the Young MCIA Steering Committee. What do you believe are the most important skills a young lawyer should need to develop today, especially in arbitration and litigation?
I think, being enthusiastic towards learning is really, the biggest takeaway that I've had. And try and see as many disputes as you can. It really broadens how you think about issues. The variety also means that, you develop as a better lawyer. Of course, over a period of time, you will find your focus. And that is something which keeps evolving. So that sort of readiness towards, learning and, to keep yourself informed of, what is happening. And that's the thing, right? I mean, there are lots of developments happening in India, both in arbitration and when it comes to litigation. I mean, there is so much happening in different practice areas that it's really about, identifying, maybe a few areas where you want to keep learning, read as much, and then, try and expose yourself to as many matters. In the initial years, I feel a generalist practice actually helps. And then over time, you can always sort of, find your niche.
Right. Thank you so much, ma'am. With this, we have come to an end of this talk. We are sure that the listeners have gained valuable insights on how to shape their careers in arbitration. Thank you so much.
Thank you.